Hello everyone, I'm Ainan Hussain Khan from Case 23 Official. Welcome back to our channel. Today we'll be discussing an important topic, witness, their types and their examination. So in this session, we'll cover all the key aspects in detail, breaking down each point for your better understanding. So in this topic, we'll be dealing with what is the witness and what is the types, examination of the witnesses, things to consider during an interrogation, and some interview questions that are asked to the witness. Now, first of all, I'll give you a brief description of what a witness is. So witnesses play a crucial role in both criminal and civil cases. Okay, their testimony often serves as a key evidence, either supporting or opposing the accused. A fair judgment is basically delivered on their statements. Whatever the statement that they give, a fair judgment is given based on that, ensuring that the justice is served. Now, if we talk about a witness in a simple term, it is any person who has the first-hand information of the crime committed. So witnesses, the statements that are given by the witness are submitted in the court of law as an evidence made under an oath. So you have to always make sure whenever a witness is giving a statement, he should give it under an oath. Whether you have to take the oral statements or a written deposition is taken, the witness must assist the court in delivering the justice by attending the proceedings whenever required. So what is the importance of a witness now? So now if you have seen everything, you can tell what is the importance of a victim. It's basically to help the court to find the truth of the crime. So Indian Evidence Act basically provides certain provisions for the persons who are capable of testifying in the court of law and its admissibility. Now if I ask you what is a witness, so witness is basically a person who witnesses any act or series of acts in a crime scene that is taking place. So witness may be any person who can perceive a fact through his senses. You have to always remember this statement. A witness can be any person who can perceive a fact through his senses. So now what is a competent witness? A competent witness is any person who perceives the given act or the act which he sees from his eyes, ears or smell or any other sensations, for example touch. Now, who can be a witness? Everybody can be a witness. Now, according to what we have read through now, we can say that everybody can be a witness. But the Indian Evidence Act gives us a proper statement, gives us a proper description of a witness. Now, Section 118, you have to remember Section 118 of the Indian Evidence states that any person can be a witness, right? Who is competent to understand the questions of the court. Is it understandable now? This section does not bar any person to testify unless he is capable of giving evidence or understanding the questions put to him because of his tender age, extreme old age, disease or any other cause of the same kind. Now any person can be a witness, right? There is no restriction as to who can be the witness. Any person is either a male or a female, child or aged can be a witness. But the only restriction is that if a person does not understand the questions of the court or is not able to answer the questions of the court rationally, then he is not a competent competent witness. Now, who is not able to understand the questions? This thing comes into your mind. If even a child, if he is able to understand the questions that are put forth by the court, he is able to understand everything. He has seen the witness, he has seen the crime through his eyes. He is a competent witness. Now if he is not able to comprehend the questions given by the court, any other old age person or any person who has a mental problem or any other problems, he is not a competent witness because he is not able to understand the questions that are posed to him by the court. Now we'll discuss about what are the types of the witness. Now we know that Bharatiya Sakshya Adhiniyam 2023 has basically replaced your Indian Evidence Act 1872 and it has provided us a detailed classification of evidences. So now we'll deal with the types of evidences in detail. First is the prosecution witness. any witness who is brought into the court to testify by the prosecution while supporting their claims. So this institution and the conduct of the legal proceedings against a defendant for a criminal behavior is known as prosecution. I guess that we already know. A prosecution is one who basically speaks against the defendant, right? Now, a police officer is almost always included in the prosecution witness, right? The police officer may testify to what information was gathered during an investigation. Now, the police officer here is the prosecution witness because he has witnessed everything through his sense organs and is competent and is able to answer the court correctly because he has gathered the information during the investigation of the crime, and he has also personally observed the accused when he was under his custody. In addition, testimony may be offered regarding any statements the defendant made to the officer after the arrest was made. Okay. Now coming to the second witness, which is a defense witness. Who is a defense witness? It is any witness who is brought by the accused in order to defend themselves. Prosecution and defense goes opposite to each other, right? So defense witness is any person who justifies the contentions of the defense by providing such statements that can discharge the accused from the charges that are filed. Now defense witness is a witness whom defendant calls whom defendant calls in order to defend the accused at the hearing or at a trial. Now the defense evidence should not be bypassed or overlooked by the court simply because the witness has deposited in favor of the accused. The trial court has to give, you have to always make sure that the trial court has to give the convincing reasons for discarding the defense evidence. So you always have to make sure whatever the defense witness says, you always have to hear it. There should be a convincing and promising reason in order to discard the defense evidence. Now, coming to the third witness is your eyewitness. For now, what is an eyewitness? The term basically speaks all about it. Eyewitness, the person who has seen everything through his naked eyes. Any person who helps the court by describing the acts that are committed on the crime scene with complete authenticity, right? As it was present there and he has the first information in hand. Now, a person who from his eyes witnesses any act or a scene of the crime is any eyewitness to that offense, right? An eyewitness may be any person like a stranger, relative, or any other person. From the perspective of the evidence, if we talk, an eyewitness is an important evidence. You have to always remember that eyewitness is an important evidence in solving a case. It is generally said that anything can betray but not the eyes, right? So you always have to make sure whatever the eyewitness says, you have to corroborate it with the evidence that is present with you. Now, fourth type of witness is your expert witness. Who is an expert witness? Any person who has a professional, educational, or judicial expertise on the matters beyond an average individual, right? And the court can rely on its testimony to declare a verdict. So, for example, we have a question document. We will always ask a person or an expert who is expert in the question documents, right? You cannot call a DNA expert for that. So what is now? Did you get the idea of what an expert witness is? So the basically he is any person that the court can rely on its testimony, in order to declare a verdict. So whenever the court needs an opinion on a subject that requires the special assistance, now what the court does is he calls an expert who is specially skilled, who is a specially skilled person. The opinion given by this third person is considered, relevant facts if the person testifying is an expert. An expert witness should always have a superior knowledge to the average person when it comes to the topic that he is testifying about. These persons are basically often doctors, forensic experts, psychologists, fingerprint experts, footprint experts, etc. Now, in order, the example that I've given you before about the question document, suppose, for example, you have got a fingerprint, and now you'll always call a fingerprint expert for his opinion. You will never call footprint experts, right? Now the evidence of the handwriting experts can never be conclusive because it's after all an opinion evidence. Okay. Now The other, now we'll talk about the other types of witnesses. First, we'll deal with the hostile witness. What is a hostile witness? Now, he's any person who has given his, information before, but then what he does is he then, keeps switching his statements. He provides false statements with no intentions to tell the truth. He keeps changing his statements every now and then. We call him as a hostile witness. The other type of witness is character witness. Now, character witness is a person who testifies in the court of law about the individual's reputation. Now, whoever the accused is, the character witness will, tell us about his reputation, his moral character, or his personal qualities that are present in the society that he has seen, so that we can get an idea about whether he can, commit such crime, or is it possible for him to commit such crime, because we now have an idea about this individual's reputation, his moral characters, or about his personal qualities. Now, the other type of evidence is hearsay witness. You have already heard about the hearsay evidence, right? Now we'll talk about the hearsay witness. What is a hearsay witness? It is basically any person who gathers the information from the other party. He basically gathers the information that he has heard from others. So, for example, if I am the hearsay witness, if other person has seen the crime scene, he will tell it to me. Then I will go to the court and I will tell what the other person has told me. I have not seen the crime scene by myself. I'm just providing you the information that I have heard from the others. Now, this hearsay witnesses is basically subjected to some legal restrictions and considerations. Uh, okay. Now, coming to the last type of witness, which is basically a child witness. Now, what is a child witness? The term suggests it's all right. A witness who is a child. Now, the children who has witnessed or been the victims of the crime now is known as child witness, right? He should have the capability of understanding the questions of the court, is called as child witness. Now, child witness also comes with special considerations for the testimony. We will discuss it, in the further slides. Now, there are other types of witnesses as well, and if you look closely, you will find similarities with what we have already discussed, the types of the witnesses that we have talked about. Now, for example, if I tell you about the chance witness, what is a chance of witness? He's any person who, by the matter of coincidence, happens to be present at the scene of crime. Now, isn't it similar to the eyewitness, right? Now, I'll give you another example of interested witness. Who is an interested witness? Somebody who gets a monetary gain from the party who has called him. Now, for example, if I tell you again the same thing as if we talk about the defense witness or the prosecution witness, those witnesses are also an interested witness because they are again any who has some interest in the case or its verdict in order to get some material benefit out of it, especially money. So, this is all similar. The chance witness and interested witnesses are other types of witnesses, but there is a similarity with the witnesses that we have already discussed previously. Now, coming to the examination of witness. Yes, now coming to the examination of witness. Examination of witness is basically an integral part of your criminal trial. Okay, it is an important part of your criminal trial. So witness testimonies are basically one of the most reliable evidence. Whatever the witnesses give their testimonies are the most reliable evidences in the court of law, because the person giving the statements has personally witnessed the event happen, right? Witnesses are required to answer the relevant questions that are presented to them. A question asked to the witness must be relevant to a fact or an issue that can help us to establish the same. Now, the answers, when recorded, are called the testimonies of the witness. Okay, these questioning of the witnesses and recording their answers is basically called as the witness examination. So, whenever you examine the witness and you record their answers, it's known as the witness examination. Okay. Now, there are some stages in the examination of witnesses. There are basically three stages in the examination of witnesses. This is given. These stages are provided from the section 142 to section 143 of the Bharatiya Sakshya Adhiniyam. 2023, which we, in short, we call it as BSA Act. Make sure this BSA Acts make sure that the examination process is conducted properly and comprehensively. Okay, it permits us it gives us a systematic approach to present and challenge the evidences, which is important in achieving the justice to the core of the law. Now, this systematic approach to witness the examination consists of three stages, which is your examination in chief, cross-examination, and re-examination. These are the stages of the what we say as victim examination. Now, these examination plays a significant role in your judicial process. It helps us to uncover the truth, test the reliability and credibility of the testimonies that are given by our witnesses. And we always have to make sure that all these relevant facts are properly examined. So whatever the facts that the witness gives us in all these three stages, we have to make sure that whatever the fact that they provide are properly examined with the evidences that we already have. Now, there are three parts to this examination of the witness, and section 138, you have to remember section 138 of the Indian Evidence Act and section 142 of BSA Act states that the witness must be examined in the following order. Previously, we had Indian Evidence Act. Now it has been replaced with BSA. So you have to be very sure about both the sections that talk about the examination of witness. I'll repeat again, section 138 of Indian Evidence Act and section 142 of Bharatiya Sakshi Adhiniyam Act gives us a proper description of the examination of the witnesses. Now there are three stages. I've already told you there are three stages. What is it? Examination in chief, cross-examination and re-examination. Now we'll talk about what is examination in chief. Now what is examination in chief? The party that calls the witnesses examines him. Now for example, if I am the prosecution, I have called somebody to give us, give us the evidence or give us a testimony. Now if I have called him and I am questioning the same person is called as examination in chief. So basically the party that calls the party that calls the witness examines him. Now this examination of chief is basically given in the section 137 of Indian Evidence Act. The initial questioning, this is the first type of questioning. The initial questioning is done by the party who is calling the witness in order to establish some supporting facts. Is it clear till now? Now, there's a second stage which is called as cross-examination. Once the examination of chief is done, we proceed to the second stage which is called as cross-examination. Now, after the completion of examination in chief, now if examination in chief was done by the party that calls the witness, but cross examination is done by the opposite party. Now if the opposite party wants to, they can take over the witness and cross question him about the previous answers that he has given in the examination in chief. Now cross examination is given in section 137 of Indian Evidence Act. Remember all these sections because it is very necessary in your college examinations or in your UGC net or fact examination. These questions are always asked in your about the sections, about everything. These questions are very much asked in your competitive exam, so you always have to make sure the proper sections. 137 Indian Evidence Act was the examination in chief. Same 137 gives us the details about the cross examination also. Now the opposing party's questioning, basically what it does is it challenges the credibility and it exposes the inconsistencies if there is any, and it also tests the witness's truthfulness. Now, leading questions can be asked during cross-examination even without the court permission. I'll tell you, in the coming slide what leading question is. But right now, just understand this. Leading questions are, can be asked during cross-examination only. Leading questions are not asked in other examinations, for example, examination in chief and re-examination, but only during the cross-examination. You can always ask leading questions even without the court permission and the objections from the opposing party. Now coming to the third stage is re-examination. Now if the party that has called the witness basically the person who has done the examination in chief does the re-examination as well. If the party that has called the witnesses now sees the need to examine the witness again after the cross examination, they may examine the witness one more time. Okay. Now, clarification by the original party focuses on the issues that are raised during the cross examination. Now, we'll talk about the other things which are, considered while interrogation. Now, what is an interrogation? You all are very aware of what an interrogation is, where a police officer or somebody else is questioning the accused. So, in order to, get a proper detail as in what crime he has done. Now, interrogation is basically a critical process in both the legal and investigative settings. Okay, whether if it is in a courtroom, police investigation, or some forensic analysis, the evidence, the effectiveness of an interrogation basically depends on the strategy, psychology, and its legal principles. So you always have to be very cautious about some points. Now, if we talk about first thing that we have to consider while interrogating is legal and ethical considerations. Now, I'll give you a brief description of what legal and ethical consideration is. Now, for first point is we always have to respect the legal boundaries that the alleged person has. We always have to follow the provisions of our replaced Indian Evidence Act, that is Bharatiya Sakshi Adhiniyam 2023, and the Criminal Code of Procedure as Criminal Procedural Code CRPC, to ensure that the interrogation is lawful. Okay, no threats should be given to the person. Forced confessions are inadmissible in the court of law, which is given in the Article 23 of the Indian Constitution Act, and it gives us, it protects us against the self-incrimination. So basically, if you try to get any detail by the force intimidation, it is inadmissible in the court. So you always have to be very sure about these legal considerations. Now, the person has the right to legal counsel. If, for example, if interrogating a suspect, they always have a right to get a lawyer. So that is your right to legal counsel. The person who is a witness, or for example, if you're interrogating a suspect, they always have a right to get a lawyer, which is given under the Article 22(1) of our Indian Constitution. Now, the second thing that we have to consider while interrogating an individual is psychological approach. Now, what is a psychological approach? First and foremost, whenever you are interrogating a person, whenever you are interrogating whether he is a suspect or he is just a witness, you always have to build a rapport. So building a rapport is very important step while interrogating. So you always have to make sure that your witness is in a comfortable position and is more likely to provide the accurate information. Second is you always have to observe his body language. Non-verbal cues can, if he is giving a non-verbal cues, you can always make sure that it can indicate he's nervous or deception or his truthfulness. Okay. Third point that you have to make sure is you always ask open-ended questions. Open-ended questions is basically you always encourage him to provide a detailed responses rather than giving just yes or no answers. You always have to make sure that whatever the questions you are giving him, he is giving you an open-ended answers. For example, a detailed response. It's not that, for example, if I say, is your name Ainan? You don't have to give questions like that. Is your name Ainan? Now he is compelled to say yes or no. But what you have to ask him, what is your name? So then this is one of the examples of an open-ended question. Now the fourth point, which is very important, is you have to use the cognitive interview technique. What is a cognitive interview technique is basically you have to ask your witness to recall all the events that had happened in the past in order to detect the inconsistencies. For example, now I will ask my witness one time that what he has seen or what he has gone through. For example, if he is a victim witness, now you ask him the same question after some time or after a day or two to in order to check if there are any inconsistencies in his statements. Okay. Now, the third point is documentation and recording. So, whatever the information that you have got from your witness, you always document it and you always record it. It is a very important part that you have to consider while interrogating. Now, always you have to keep a detailed notes. Record every response that your witness has given you. You have to record every response accurately. Use audio video recording. Sometimes what happens is some statements may need official documents for legal proceedings. So make sure you always have the audio recordings as well and the video recordings as well. You have seen in a movie, so for example, when there is an interrogation happening, you have seen that they put a mic, they put a mic before the accused, or and also they put a video camera in front of the accused, so that they can record everything, whatever he is saying, and it should be admissible in the court of law. Now, third point that should be kept in mind about the documentation and recording is you always have to verify and cross-check his statements. So now you always compare the statements with the available evidence in order to confirm the credibility. Okay, so these are the basic things that you should consider while interrogating a witness or an accused. Now we come. Now we you should always there are. I'll give you just some before discussing the interview questions. I'll just give you some tips that you should be very aware while questioning a witness. Always you should make sure that your questions are clear and direct. You should always avoid leading questions unless and until it is a cross examination that's going on. You should always observe the body language and consistencies in the responses of the witness, and you always have to be very patient with the hesitant or emotional witnesses. Okay, these are basically the key points that you have to keep in mind. Now, coming to our last point of the presentation, which is the interview questions. Now, for example, now you have a witness before you, right? Now, what are the questions that you're going to ask him? Now, you know the tips, but what are the questions that you have to ask him, right? So first we'll talk about the leading questions. We have already discussed it in previous slides. So if you talk about leading questions is basically described in section 141 of Indian Evidence Act and 146 of Bharatiya Sakshi Adhiniyam Act. Leading questions are basically any questions that suggest the answers that the person questioning expects to receive. Okay, now for example, it's basically if I tell you in a very simple terms, it's any question that for example, if I ask somebody a question, so I'm expecting the answer. The question is in such a way, it's posed in such a way that whatever the answer that I'm expecting, I is given by the witness. So you're not supposed to ask the leading questions in your examination in chief and re-examination. It's as simple as that. So for example, if I ask you was the culprit wearing a white hat? Okay, didn't he? So you already know that the culprit was wearing a white hat. So this is a leading question. Okay, you are already giving the person a hint that the culprit was wearing a white hat. So this question is leading the witness to reply with what the questionnaire wants. Okay, now in this case we should always ask what was the culprit wearing. So this is not a leading question. This leading question should always be questioned in cross examination and not in examination in chief and re-examination. Leading questions are generally prohibited during the examination in chief and re-examination, but you can ask them unless you are permitted by the court of law. Okay, so this was your leading questions. Now we'll talk about the lawful questions. Lawful questions are basically, so the witness statements will be taken as evidence by the court, but it must be proved that the witness is actually telling the truth, are basically your lawful questions. Okay, this lawful questions is given in section 146 of Indian Evidence Act, and it states that during the cross examination of the witness, you can add some questions, during the cross examination you can add some questions. Why should you always add some questions, basically the lawful questions, so that in order to test the accuracy or the truthfulness of the witness, and you should always understand more about the witness and his position in life. That is your lawful question. Okay, now the third point is questions should always be on the reasonable grounds. So whatever question you ask should always be on the reasonable grounds. It should not question his character, or it should not shake his credit. It should always be it should be on a humane level. You should not be the inhumane one to the witness, because maybe he is a victim and he has gone through so much, so you always have to be on the reasonable grounds. Now, we'll talk about the effective questioning techniques. What is an effective questioning techniques? First is the direct question. Effective questioning techniques, first is direct questions. Your question should always be simple, clear, and specific questions which can help you extract the factual information. Second is your leading questions. Leading questions, I have already talked about it a couple of times. It's always allowed in cross examination. Very good. It's used to test the witness's consistency. For example, if I ask somebody that is it true that you saw the suspect at 10 p.m. Now this is a leading question, right? Because I'm giving him a hint and I want to answer him, yes, I saw him at 10 p.m. So this is a leading question. So you always have to be you always have to make sure that you always ask the leading questions only in cross examination. Now, there is another a technique called as probing questions. What is probing questions? Is basically you encourage the witness to provide you more details. Okay. Now, for example, you ask him, "Can you please describe, what happened next? What happened next?" These is your all these questions is your probing questions. Now, the next is clarification questions. What is a clarification question? Is where it is used to resolve the contradictions. Okay, this is your clarification questions where you try to resolve the contradictions. You get a better clarification. Okay, for example, you will ask your witness that you earlier mentioned about the person X, and now you're saying he is not the person. I'm talking about person Y. Just say, for example, now the witness has talked about the person Ainan, and suddenly he has just said, no, I don't know who Ainan is. So you always have to make sure that whatever you're asking has a basic clarification. You try to resolve the contradictions. You ask him again and again. You have talked about Ainan previously. Who is she, and what is the the link of her to the crime scene and everything. So this is your clarification questions. Also, you ask about them the general background things, general background questions. For example, it helps us to establish the witness's credibility. For example, what is your full name, your age, occupation, how do you know the victim, or how do you know the accused, and where were you all the time. You have seen in the movies and everything, the first thing, first question that the interrogator ask is like, where were you at all the time during the time of incident, right? And how well do you remember the events of the day? These are your general background question. Now, other questions are the questions that are given that are for an expert witness. The question that you can ask the expert witness, and that you can ask the some hostile or vulnerable witness. So questions for the hostile witnesses is basically, why is your testimony different from your earlier statements? I've already told you that with hostile witness changes his statements every now and then. So you have to ask him, why is your statements different from the previous statements? Or have you been threatened or influenced by anyone? Or did you sign under any pressure? Or do you remember anything what the police officer has told you earlier, or he has threatened you or influenced you? So you have to ask these questions to the hostile victims. Also, to the vulnerable victims, for example, the children, or the vulnerable witnesses is the children or victims, etc. So you can ask the questions, for example, can you tell me what has happened to you in your own words? You can ask these questions to the children witnesses, or you can ask them, do you feel safe about whatever the questions that are being asked to you? Or do you need a break, or do you need someone else who can come and support you? Or was there anybody else present who can confirm what you're saying? So these are all the questions that you can ask to a vulnerable witness. There are also some questions that you can you can question the eyewitness. For example, you can question him, what do you actually saw, or what time did the incident occurred, how far you were from the crime scene, or did you hear any sounds or any conversations, or for example, were you under any influence of alcohol, medication at that time? You can ask all these questions to the eyewitness. Now, the questions that you can ask to the expert witness is basically about his qualification and his experience. You can ask him, have you worked on such a case before in your life, or what tests did you conduct, and what were the results? about these examination, or whatever method you have used, is how much is it reliable. So you can always ask these questions to the expert witness as such. So this is basically the effective questioning techniques that I have, that you can ask to your witness. Now, coming to the conclusion of this topic, so whatever, depending on the nature of the case, so there are special considerations that are given to the vulnerable witnesses that I have told you before. Vulnerable witnesses, as in some women witnesses or child witnesses or some old age witnesses, these are your vulnerable witness. So you always have to make sure that special considerations are given to these witnesses. Okay, now you always have to make sure that you use an appropriate language to these witnesses, and you always have to make sure that there's a comfortable environment for these child witnesses, and you also always should make sure that there is given a privacy to the victims of the crime, and you should always be very humble and very should always be very helpful and provide assistance to your elderly or disabled witnesses. So that was all from my side today. Thank you for all being such a wonderful audience. If you have any doubts or questions, please feel free to drop them in the comment section, and I'll make sure to respond them accordingly. Don't forget to like, share and subscribe for more such content. See you in the next video. Bye bye.